It is Streeter Marshall's responsibility to ensure you all understand the law and our own policy and procedures on anti-money laundering and counter-terrorist financing. Therefore, the partners of Streeter Marshall have put together this anti-money laundering presentation. It's a big topic and today is a bumper session. Full compliance with anti-money laundering and counter-terrorist financing laws requires the commitment and participation of every employee. Your support and active involvement is critical in ensuring that we adhere to the laws and policies prohibiting money laundering and terrorist financing. I will be guiding you through today's training session, which will cover Part 1. What are money laundering and terrorist financing? Part 2. Red flags, recognizing warning signs. Part 3. The law. Part 4. Reporting suspicions. Part 5. Client due diligence. Part 6. Receiving funds. Part 7. Responding to investigations, screening, training and monitoring compliance. Money laundering is the process through which proceeds of crime and their true origin and ownership are changed so that the proceeds appear legitimate. Terrorist financing is providing or collecting funds from legitimate or illegitimate sources to be used to carry out an act of terrorism. Typically, money laundering involves 3 stages. 1. Placement, the process of placing criminal property into the financial system. This might be done by breaking up large sums of cash into smaller amounts or by using a series of financial instruments, such as checks or money orders, which are deposited at different locations. 2. Layering, the process of moving money that has been placed in the financial system in order to obscure its criminal origin. This is usually achieved through multiple complex transactions, often involving complicated offshore company structures and trusts. 3. Integration, once the origin of the money is disguised, it ultimately must reappear in the financial system as legitimate funds. This process involves investing the money in legitimate businesses and other investments such as property purchases or setting up trusts. We are most likely to become involved in the layering stage, but potentially could be involved in any stage. Lawyers facilitate significant transactions and are gatekeepers to the legal system. The anti-money laundering and counter-terrorist financing regime is designed to prevent our services being used by criminals. We all have obligations under the anti-money laundering and counter-terrorist financing to spot and report money laundering and terrorist financing. Failure to meet these obligations can lead to criminal penalties, substantial fines, disciplinary action by the Solicitors Regulation Authority, and untold damage to your own and the firm's reputation. We have robust systems to ensure that details of the firm's bank accounts are only disclosed to clients and third parties where necessary. Particulars of such disclosure are set out in our cyber fraud policy, which we send out with our initial engagement letters, and a copy of which you can obtain from our compliance folder on our V drive. All managers and staff must understand that members of the accounts department must not be pressurized into actions or omissions that place the firm at risk of involvement in financial crime. Where a member of the accounts department has concerns about a matter or transaction, they are expected to consult their manager, the compliance officer for finance and administration, COFA, or nominated officer. The accounts department will always consult the nominated officer before taking steps to return any unidentified funds to the originator or elsewhere, and an explanation will always be required for payments into or out of client account by or from a third party. You do not have to behave like a police officer, but you do have to remain alert to the red flags and warning signs of money laundering and terrorist financing and make the sort of inquiries that a reasonable person with the same qualifications, knowledge and experience as you would make. Our awareness tool, Recognizing Crime, Red Flags and Warning Signs for Staff, can be found in the V Drive Compliance Policies folder. It identifies typical red flags and warning signs that may indicate that our firm is involved in or is itself being used to commit crime which would normally require further investigation. We have broken these down into 3 categories: I, the client; 2, the money; 3, the transaction, and then signs to look out for in specific areas of work. These factors do not automatically mean that crime is taking place, though they can be considered red flags. You should pay particular attention to matters where a number of factors are present. Note that criminals are always developing new techniques, so no list of examples can be exhaustive or fully comprehensive. So we've said we must make the sort of inquiries that a reasonable person, with the same qualifications, knowledge and experience, would make. What does that involve? The sort of inquiries you should be making should give you a clear understanding of: is the documentation you have consistent with what you are being told and know about the background, nature or circumstances of the client? Does this make sense? How is the deal being financed? Where is the money coming from? How does the client expect to benefit from the deal's matter? Where are the proceeds of the deal the matter going to? If not to the client, why not? Who are the people behind any company? Who are the parties involved? Does the size of the transaction match your knowledge of the client's finances and typical transaction size? If you have any concerns, you should discuss these with the money laundering compliance officer. So now we know what money laundering and terrorist financing are, why they are important to us and what they can look like. We'll move on to see what the law says about them. The Proceeds of Crime Act 2002, POCA 2002, establishes a number of money laundering offences. These can be broken down into the principal offences, failure to disclose offences, and the offences of tipping off and prejudicing an investigation. First, you should note that all money laundering offences relate to criminal property, which is property that constitutes or represents a person's benefit, in whole or in part, from criminal conduct, whether directly or indirectly. This definition covers the proceeds of all crimes. There is no minimum limit on what is considered to be criminal property. Criminal conduct is all conduct that constitutes an offence in any part of the UK, or overseas conduct that would constitute a criminal offence in the UK that would attract a maximum sentence of more than 12 months imprisonment. So first are the principal offences. You will commit a principal money laundering offence if you conceal, disguise, convert, transfer or remove criminal property from the UK. Enter into or become concerned in an arrangement that facilitates the acquisition, retention, use or control of criminal property for or on behalf of another, or acquire, use or have possession of criminal property. Let's look at each of these offences in turn. Section 327 provides that you will commit an offence if you do any of the following with criminal property or any rights with respect to it: conceal, disguise, convert, or transfer criminal property, or remove criminal property from the UK. This includes concealing or disguising its nature, source, location, disposition, movement, or ownership. You must know or suspect that the criminal property represents a benefit from criminal conduct. Section 328 says that you will commit an offence if you enter into or become concerned in an arrangement that you know or suspect facilitates, by whatever means, the acquisition, retention, use or control of criminal property, by or on behalf of another. Arrangement isn't defined in POCA 2002, though POCA 2002, S. 328 catches a wide range of involvement in money laundering offences. It can easily catch you when you are conducting transactional work for laundering clients. However, S. 328 will not catch legal professionals conducting genuine litigation or complying with or carrying out the terms of a court order. But remember that any property will remain criminal after litigation has concluded and any resulting court order implemented, so you may decide to advise the client to seek advice in relation to the property from an independent legal professional. For example, in matrimonial proceedings between husband A, a criminal, and wife B, the court orders the transfer of the matrimonial home from A to B. The matrimonial home represents the proceeds of A's crime. You will not commit the arrangement offence by effecting the transfer under the court order. However, the matrimonial home remains criminal property in B's hands. If B later instructs you to transfer the property, you will commit the arrangement offense if you do not first disclose your knowledge about the property and receive appropriate consent from National Crime Agency, NCA, to transfer it. Entering into an arrangement means becoming party to it. Being concerned in an arrangement has a wider scope, e.g. taking steps to put an arrangement in place. Preparatory or intermediate steps that do not in themselves involve the acquisition, retention, use or control of property will not constitute the making of an arrangement. Section 329 makes it an offence to acquire, use, or have possession of criminal property. Having possession means having physical custody of the criminal property. The principal money laundering offences carry a maximum penalty of 14 years imprisonment, a fine or both. Defence. You will have a defence to a principal money laundering offence if you submit a suspicious activity report, otherwise known as a SAR, to the MLRO. Making a SAR to the nominated officer can be a defence to a principal money laundering offence. POCA 2002 and the TA 2000 also impose obligations on us to report knowledge or suspicion of money laundering by way of a SAR. These obligations can override our strict duty of confidentiality to our clients. Failing to make a SAR to the nominated officer where you know or suspect money laundering is an offence in itself and is punishable by up to 5 years imprisonment, a fine or both. You will commit the tipping off offence if you disclose that you, or anyone else has made a suspicious activity report, SAR, to the nominated officer, or to the National Crime Agency, NCA, of information which came to you in the course of business, and that disclosure is likely to prejudice any investigation that might be conducted following the SAR. You will commit the prejudicing an investigation offence if you disclose that an investigation is being contemplated or carried out and that disclosure is likely to prejudice that investigation. Further, you will commit an offence if you know or suspect that an investigation is being or is about to be conducted and you interfere with documents that are relevant to the investigation. Tipping off can only be committed after a SAR, including an internal SAR to the money laundering reporting officer, has been made. All these offences are punishable by up to 5 years imprisonment, a fine or both. You will not commit a tipping off offence by discussing your concerns with or submitting a SAR to the MLRO. It is not tipping off to warn our clients of our duties under the anti-money laundering and counter-terrorist financing regime by providing them with our terms of business and/or our client care letter. And the existence of these offences does not prevent you from making normal inquiries about your client's instructions. You are able to make inquiries in order to obtain further information to help you decide whether you have a suspicion and/or remove any concerns that you have. Your inquiries will only constitute an offence if you disclose that a SAR has been made or an investigation is being carried out or contemplated. Before establishing a business relationship with a corporate, trust or registrable overseas entity client, we must collect proof of registration or an excerpt of the register, e.g. the register maintained by Companies House. If we find a material discrepancy between the beneficial ownership information on the register and the information made available to us in the course of carrying out our client due diligence exercise or ongoing monitoring, we must report it to the registrar. While it is unlikely that making a material discrepancy report where required in itself would amount to tipping off, you must exercise caution where you consider it necessary to submit both a SAR and a discrepancy report. If in doubt, seek advice from the nominated officer. We will go into more detail about discrepancy reports shortly. Finally, let's look at the terrorist financing offences that are contained in the Terrorism Act 2000, TA 2000. Terrorists need funds to plan and carry out attacks. The TA 2000 criminalizes both the participation in terrorist activities and terrorist financing. In general terms, terrorist financing is the provision or collection of funds from legitimate or illegitimate sources, with the intention or in the knowledge that they should be used in order to carry out any act of terrorism, whether or not those funds are in fact used for that purpose. The TA 2000 establishes a similar pattern of offenses to those contained in POCA 2002, that is, principal terrorism offenses of fundraising, use or possession, arrangements, money laundering, and other offenses of failure to disclose and tipping off. All offenses carry heavy criminal penalties. While the terrorist financing and money laundering regimes are different, they share similar aims and structures and run together in UK legislation. Many provisions of POCA 2002 and the TA 2000 mirror one another, and the definitions are deliberately matched. Both POCA 2002 and the TA 2000 run parallel to the Money Laundering Regulations 2017. The Money Laundering Regulations 2017 form part of the UK's overall anti-money laundering and counter-terrorist financing regime. They set administrative requirements which run parallel to the criminal element of regime contained in the POCA 2002 and the TA 2000 and various pieces of sanctions legislation. There is some overlap. They have been amended a number of times since coming into force in June 2017. Requirements in this training session and our anti-money laundering and counter-terrorist financing policy reflect the amended MLR 2017.